matter, Your Lordship.
Yes, the provision of appeal is available.
Yes, Your Lordship. So, Mrs. Tapa is not
What-
available, Your Lordship.
What do you gain by taking adjournment? Just tell us.
Your Lordship, today is
It's a small issue to be decided.
Lordship.
Whether it should go before appellate forum or whether its writ is maintained. Yes.
Is there already informed us, so we have no objection about it.
7 also. Same order after a week at the request of the petitioner. Yes.
Hello,
Your
pleasure.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 8, Your Lordship. Item number 8. Your Lordship, I pray if this matter may come up after 1 week, Your Lordship, as the Leonard DHGI is indisposed, Your Lordship.
1 week. If he's indisposed, my lord,
It at the request of the respondent. List after a week. Yes.
publish.
He's not well till now.
Yes, Your Lordship, is still not well.
Publish.
Your Lordship, similar prayer for item number 11, Your Lordship. I'm praying on behalf of Mr. J. Shila, Your Lordship. Due to some personal difficulty, Your Lordship, I pray if this matter may be taken up after 2 weeks, Your Lordship.
11. Who is the other side? Yes.
First state, my lord, I have no objection.
Yes.
Much
11 after
obliged,
2 weeks at the request made in view of the petition. Yes.
Much obliged, Lordship.
My lord, I beg to make mention of item number 14 on behalf of Mr. Andy Shulai. He's indisposed, my lord.
Mr. Shula is indisposed.
Lordship.
He was here yesterday.
He's out of station, my lord. My lord, I pray if the matter can come after 1 week, my lord.
Who is the other side? You are not visible, Mr. We cannot see you. Any objection?
My lord, yes. If the other side is having difficulty, my lord, no issues, my lord. It can come up after a week, my lord.
This also after a week. The request made on behalf of Mr. Andy Shula.
Deeply obliged.
Learned age. Registered. Yes. Yes.
My lord, I beg to mention item number 12, my lord. This is regarding, my lord, quashing of the POXO proceedings.
Yes.
So, my lord, this matter also may come up after 2 weeks, my lord. Because the similar matters are all fixed after 2 weeks, my lord.
This quashing is sought on what ground?
On the ground of consensual relationship.
Now, this is an issue, I think probably it has gone to division bench.
My lord, that's why, my lord.
Yes.
So, my lord, may fix it
And,
after 2
of
weeks.
course,
It's given for reference.
Reference.
Lordship
Yes.
has referred it for reference.
Yes.
For the division
then
bench.
any
So
idea
the-
whether this when,
Yes, yes.
when this
Lordship,
matter is coming up?
It is not. No, Lordship. The matter has been decided. So, like, order is going against the case of the.
But
against them.
this has been decided by the
It
division
has
bench.
been decided, Lordship. That the matter which was referred by your Lordship before the division bench, it has been decided.
Is it?
I just apprised. The matter came up last week and heard the matter to some extent. And the prosecutor informed the court that similar cases pending in Supreme Court and coming up on 9 of next month. So the division bench just deferred the hearing of the case deferred from the court. We come up in the month of last part of July.
So it means it is not decided.
No, no,
Not decided. Until then, Lordship. it's
Not
not-
Why you are saying that is decided? This court was surprised that it is decided so fast. Anyway, then when do you want it then?
After 2 weeks, my lord.
We'll have it.
Yes, Lordship.
Yes. So after 2 weeks, any likelihood that that matter will be decided?
No, Lordship.
Then
It's probably.
My lord.
is there any use waiting for that? Or if you have any other law?
No, my lord. Let it come up after.
Anyway, we will have it after 2 weeks. Just at the request of the parties, at the joint request of the parties, list after 2 weeks. Okay.
Obliged.
Published.
From supplementary cost list, item number 1.
Yes.
Yeah, please, Your Lordship. Your Lordship, let the matter be called up after some time. The connecting council is unlike before DP, Your Lordship.
This court could not hear anything. Say loudly.
Let the
Come,
matter
come
be.
near the speaker.
Let the matter be called up after some time, Your Lordship.
After some time.
Yes, Your Lordship. The connecting council is unlike before DP.
Okay.
Obliged, Your Lordship.
Item number 2. From the main list, item number 1. Highly obliged, Lordship. Item number 2.
May it please your Lordship. Lordship, I pray if this matter may be taken up after 2 weeks, Lordship.
My lord, I have no objection, my lord, regarding my learned friend seeking time, my lord, but the issue, the prayer in this petition, my lord, is very limited, my lord. Very limited, wherein, my lord, the learned trial court had, I just want this honorable court to remove the observation done by the learned trial court, wherein the learned trial court, while rejecting the order, has touched the merits of the case, my lord.
Merits of the case.
Yes, my lord.
What is that merit of the case?
My lord, may I take your lordship's?
Without referring to merit, can a bail be totally decided?
My lord?
Without referring to merits of the case as it exists,
Yes, my lord.
whatever appears,
Yes, my lord.
without attaching any finality to that, can a bail application be decided?
My
without
lord,
referring to the facts of the case.
my lord, there is a law, my lord, wherein the observation has been done in a law, my lord, that is a standing instruction 1 by 89, my lord. That requires to be removed so that I can rely that at the time of the trial court, my lord, at the time of the final argument in the trial
What is
court.
observation on merit?
My lord, the learned trial court, it is at the last part, my lord, page number 12, my lord. May I take your lordships to page 12? Page 12 of the impugn order, my lord.
Yes.
The last para, my lord.
Yes.
Peruse the evidence record before this court. The main ground of challenge is non-compliance of the standing order 1/89 at serial number 2.8. The learned counsel appears to be confused with the said instruction. The instruction at 2.8 of the standing order 1/89 pertains to withdrawal of representative samples and not to the stage where the IO conducts the preliminary test on the suspected contraband. This court is unable to accept the submission of the learned counsel since there is no other ground taken. The accused is being tried for the commission of an offence
What is wrong in it?
My lord, this observation shall be removed so that, my lord, I can rely on the same.
Why? This is the ground of rejection. That is what.
My lord, but this is the law, my lord. Now, once the learned trial
The law
court
means
this is a standing.
If you raise a plea before the court cannot reject it by given reason.
My lord, the reason laid by the trial court says that the standing instructions, my lord, is not applicable.
Yes.
But my lord, the standing instructions are applicable since they are mandatory in nature, my lord.
How?
My lord,
That is a disputed things.
my lord, can I take your lordships to page 263, my lord? This is the law and regulations, my lord.
No, we cannot do that. Anyway, we'll just have it when you want after 2 weeks.
2 weeks.
At the request of the respondent. What is reference to merit? Just tell us. If you seek some relief on the basis of certain law,
Yes,
and court doesn't agree it and says that you are not correct, so
But
you
my-
say the court cannot do it.
My lord,
That means it was you want to say the court should have agreed with you.
my lord, I'm not saying that, my lord. My humble submission is that, my lord, that observation, my lord, has violated my right. That observation, so that, my lord,
If
these
you reach certain
instant,
point- if you
these
reach certain point that has been rejected by giving reason. And this is done in a bail application. I don't think it will have any application when this ultimately comes up for
my lord,
hearing.
when there is a judgment also, my lord, wherein the learned,
Just sit with the request of so and so list of activities. Yes.
highly
Item
obliged, my
number
lord.
3.
Yes.
My lord, I have for the petitioner, my lord, on the last occasion, that is on
Which matter?
item number 5, my lord.
My lord, item number 5 and supplementary
Okay.
item number 1, they are from the counter.
On the last occasion for the private respondent, for the complainant, had sought for time, my lord. I'm seeking for more time because, my lord, the affidavit is ready. However, he's not in town, my lord. He's gone for treatment.
Yes.
I'm just waiting.
What about your instruction?
Yes, my lord. My lord, supplementary number 1 is the main FIR, my lord. And then here my lord, here is a counter FIR. It's from the same case, my lord, more or less from the same case.
My lord, this case is the main FIR.
And supplementary
the
is supplementary, my lord.
We do not have to do with counter. Just say what happened
My
here.
lord, here, my lord,
What is the progress of investigation here?
my lord, it's still at the preliminary stage
These
of
are
the
all
investigation.
small
My
things.
lord,
I do not know why you keep
my lord, we
pending.
have issued notice on the 12th of June under 41 for the Mr. Youngrai to appear, my lord. He has sought for 1 month time, my lord, since he has gone for treatment to Delhi.
No, but then here
So,
this
unless
petition is
until-
here. It is petition is by somebody else.
My lord, yes. Here
We
he
are
is,
not concerned with
My
the
lord.
Youngra is private respondent.
he is a
So we have
complainant, my
nothing
lord.
to do. This is an FIR filed by you.
Yes.
Yeah. Now, what is the stage of the investigation so far as this is concerned?
My lord, the investigation is going on, my lord. And we are not able to go smoothly because one or the other way, my lord, the parties
No,
concerned here are
the
not coming
issues-
forward for their
These are
statements,
the
my lord.
issues why it is kept alive. We do not know the small issues.
My lord,
Is
they
it
are
very
not.
difficult case to investigate? Difficulty in finding out culprit.
My lord, we are doing the investigation. The only issue here is that the parties are not coming forward. They are not. They have one or the other reason for not coming, my lord, for the investigation process, my lord. Now here also the complainant
You want to
himself
say
is
even the complainant is not cooperating?
complainant has gone for medical treatment now, my lord. That is also another reason.
See, if he is complainant, there is no question of issuing section
My
41
lord,
notice to complainant.
I do not want to use the word not cooperating, my lord.
No,
But the
you
only
say
thing
it, you
is that
say
we are
it
having
that
difficulty.
you say it that the section 41A notice was issued to the
The complainant in the other case, my lord, in the supplementary matter, my lord.
We're talking about this case.
My lord, here.
Why you are connecting this other case with this?
My lord, the entire case is coming in circle, my lord. So that's why the investigating officer also has to go all together.
One page, I'll just show you, Lordship. Quite disturbing. Lordship, can you have page 31?
Page 31.
This came to my notice.
Yes.
Now, my lord, this is an order transferring, my lord, the FIR from the PS, my lord, to the CID. And that has been done by the accused person.
That is just because to ensure that this investigation is not influenced by this, because that PS was directly under his control.
Even CID is under his control, my lord.
Whatever it is, but then it was under direct control. See, that way definitely top ranking holder will have control, but then direct control and indirect control has some difference.
He could not have passed. That is my question.
So anyway, which way this will have a bearing so far as the allegation made in the FIR is concerned? That is, let them take a call. When you finish this investigation, why
My lord,
you are keeping it alive?
once, my lord, we are able to reach the complainant himself, my lord, we will be able to.
Mr. Philippon Nangvi, Learned Counsel, appealing for the rest number 2. 6, grant of further time. For
In 4 weeks.
filing an objection, isn't it?
4 weeks, you should take 4 weeks.
We'll say objection in the matter, Mr. Nangvi. Filing an objection in the matter. Alert list of 2 weeks. We'll have it after 2 weeks.
Lordship, can it be after 14th of July, my lord? After 14th, my lord.
Interim orders then.
What date is this? Today is what date?
Today is 21st.
21st.
This is for 3 weeks. Make it 3 weeks.
3 weeks. Highly obliged, my lord.
Hearing from supplementary cause list, item number 3.
Yes, Mr. Sangresho, what is here?
My lord, this matter, Lordship, can you recollect the petitioner was removed from the post of science SSA teacher and replaced by the headmaster, and the argument was advanced, and Lordship, after hearing me, the question was put forward to the other side also, that the NCTE norms, which they have claimed that he has fulfilled, it appears to be he also not fulfilled. Therefore, he sought timely occasion to supply the documents and to justify that he has fulfilled the norms.
Now, supply the documents like this. What is for preparation of documents? You're not supposed to bring new documents.
New documents, but he has
Any new documents have been brought in here.
my lord, he has given some
So how can you
notification in
bring new
others.
documents? You cannot look into new documents.
The documents is there, Your Lordship, as court just advised me to produce this one. How this respondent number 7 was appointed, and when this school was recognized. These are the matters.
No, that is okay, but then if until and unless those documents are made a part of pleading, how the other side will respond to it?
My lord,
They may dispute it. These are all public documents.
this is my lord.
Official documents.
My lord, yes.
It can be taken judicial notice of.
Yes, notifications and the acts and rules.
So you will not have any problem with
my lord, and some part is a managing committee resolution, which he's supposed to annex in his counter. He did not, but his statement is there in his affidavit.
So you are not objecting to any of the inclusion of any of the documents.
The only issue is whether he has fulfilled the NCT norms or what, and he claims he's supposed to give reply. Let him give reply.
But so far as you are concerned, it is an immediate question that you have not fulfilled.
Yes, yes, yes. That is my contention.
So if you do not have fulfilled, then you do not have any legitimate claim over the post.
In my since it is a contract under the SSA, those who finish class 12, they are eligible, and on that basis I was appointed. Now he say that I was appointed illegally without fulfilling the norms, and the norms they refer to is the NCT norms.
You did not provide any notes of your bullet points of your. Have you provided? No, not provided.
Well, that synopsis is not there, but Lordship asked me to submit the list of documents.
Anything, but then if you give us bullet points, then what happens when these cases are heard in piecemeal? That helps us recollect.
Well, at the time of conclusion, if Lordship allow us, we'll give the brief notes.
If you give the bullet points, then it becomes easy.
Right. Lordship, I have submitted the list of documents earlier occasion. Yes. There, if Lordship will come to page number 40. This is the contention of my other counterpart, the friend.
Page
number 40
of this
of my list of dates, the list of documents.
So at least one thing is here that none of the documents are disputed.
Yes.
Here. These are all admitted documents.
Admitted documents.
Yes, page 40.
Yes.
Yes.
This is the NCT notification 23rd August 2010.
Yes.
Now, he claims that I do not fulfill this criteria. Lordship, kindly come to page number 41.
Yes.
Class 6 to 8.
Yes.
It says BA PSC and 2-year diploma in elementary education, or BA BSc with at least 50% marks.
Take your seat. We'll just.
Yes. And 1-year bachelor education B.Ed, or BA BSc with at least 45 marks and 1-year bachelor in education B.Ed in accordance with the NCTE recognitions and such, or senior secondary or equivalent at least 50 marks and 4-year bachelor in elementary education, or senior secondary or equivalence at least 50 marks and 4-year BA BSc education or BSc education, or BA BSc with at least 50 marks and 1-year B.Ed special education. This is to deal with the special children. And this is important, pass and teacher eligibility tests to be conducted by the appropriate government in accordance with the guidelines framed by the NCTA.
That is in addition to that.
Yes. So two essential qualifications are there. Those BSc and B.Ed, since it is science paper, I may not refer to BA, plus pass in teacher eligibility test. Now, teacher eligibility test is conducted by each state government, and Meghalaya also conducted. We call it MTEC, Meghalaya Teacher Eligibility Test. These are the two essential criteria. Now, I did not have this qualification. So also he. And he said yes.
But then this is a notification of 2010.
2010.
It will have application, it will not have retrospective.
Yes, it doesn't have.
Now, your recruitment is after this.
Yes.
His recruitment is prior to this.
Yes, his recruitment is 2002, and mine one is 2014. So this notification comes in 2010. Now, therefore, my lord, the law has provided what would be the condition for those teachers who were appointed prior to this notification. My friend has taken the shelter, my lord, page number 42.
Yes.
Point 4.
Yes.
Point 4. Last time he has vehemently argued on this point. Teacher appointed before the date of this notification. Now it says, but the following categories of teachers appointed for class 1 to 8 prior to date of this notification did not acquire the minimum qualifications specified in paragraph 1. So it is very clear. But they have to fulfill the other condition, that is, a teacher appointed on or after the 3rd September 2001, that is the date on which the NCT determination of minimum qualification for recruitment of teachers in schools regulation 2001 as amended from time to time came into force in accordance with that regulation. So those who are appointed who fulfill the criteria mentioned under the regulation 2010. Yes, that is one.
What just
Provided
read it again. This A, what does it say?
A teacher appointed on or after the 3rd September 2001, that is the date on which the NCTE determination of minimum qualifications for recruitment of teachers in schools, regulations 2001, as amended from time to time, came into force in accordance with that regulation.
What does it mean?
Yes, according to me, my lord, those who...
What meaning this portray? This A?
Now this, if I understand properly, now this...
Something is missing in the here.
The language may be, but I'll try to, my lord.
Difficult.
Yes, I'll try to submit that this regulation 2001 came into effect on 3rd September 2001. That's what it says.
So,
any person appointed who fulfilled the criteria mentioned in that.
On or after 2001, this criteria mentioned in regulation will apply.
Will apply. Provided it says a teacher of class 1 to 5 possessing B.Ed qualification or a teacher possessing B.Ed special education or D.Ed qualification shall undergo NCT recognized 6 months special program on elementary education. So those who fulfill the norms under the 2001 also get appointed. One has to undergo 6 months training.
But then this is not a requirement for induction service. This can be after the person is taken into service. That 6 months per month.
Yes. After a person get the appointment and he can undergo 6 months. A teacher of class 1 to 5 with B.Ed qualification who has completed 6 months special basically. This is for a teacher appointed for special students. A teacher appointed on in accordance with the relevant recruitment rules. Now here, it is very clear that NCT norms of 2010 will not apply to those teachers who were appointed
before 3rd September.
Before 3rd September, who fulfill the eligibility criteria under the regulation 2001.
According to the prevalent recruitment rules at that point of time. Yes. Anyway, this is A and C carries the same meaning.
Yes, same meaning. Same meaning. Therefore, last occasion I have submitted the that regulation.
Yes.
Regulation I have given.
Yes, it's there. 3rd September 2001. Is it 3rd September 2001?
3rd September. Yes. Now, Lordship, can you see regulation 3, qualification for recruitment?
Yes.
It says the qualification for recruitment of teachers in education institutions mentioned in section 2 above shall be as given in the first and second schedules to these regulations. The qualifications prescribed in the first schedule shall apply for recruitment of teachers for teaching school subjects. The qualification prescribed in the second schedule shall apply for recruitment of teachers for physical. We are not concerned. Now, may I come to first schedule we are concerned with?
Yes.
The next page, the first schedule. Now, the first schedule, 3 categories are there. Number 1 is elementary. Now, primary, we are not concerned.
Yes.
Now, for primary, 3 qualifications are required. Now, for upper primary, here the present school is concerned with upper primary middle school section. Now, for this qualification is provided, number 1, senior secondary school certificate or intermediate or its equivalent, and diploma or certificate in elementary teachers training of a duration of not less than 2 years. I don't have, and so also the private respondent also doesn't have. Or it says Bachelor of Elementary Education BELIT. I don't have, he also doesn't have. or graduate with Bachelor of Education, B.Ed, or its equivalent. Both of us doesn't have.
What is the qualification of the respondent number 7?
My lord, he mere graduate, and he got appointed in 2002. He continued.
So what is the equivalent qualification of Bachelor of Education?
But Bachelor of Education.
What is the equivalent or its equivalent?
Equivalent. This will be for it is not the graduates. It is not the graduate. It is for Bachelor of Education. A person who is trained for teaching.
Graduate with Bachelor.
Yes. So mere graduate will not fulfill the essential criteria here. So admittedly, he also doesn't have. I also don't have. And
no, for you, it is not. This will not apply to you. You will be guided by 2010 notification.
Yes.
So this is only for him.
Yeah, for him, since he claimed that he is exempted under NCT norms 2010, therefore I'm giving reply that he even did not fulfill the criteria mentioned under Regulation 2001.
Then,
so
assuming what you say correct, then what happens?
So therefore, the cancellation of my appointment and replacing me by him is illegal. Because the law is very clear, Lordship is very clear. A wrong person cannot be replaced by another wrong person.
But then how, in view of the fact that admittedly you do not also have the qualification, how can you be retained?
In that event, they could have terminated me, citing these are the ground, you are wrongly appointed without adhering to the regulation at that point of time.
So you are not terminated?
I was terminated.
No, but then that means...
And they went further and appointed him. So therefore I challenge
in your place.
In my place. That is my grievance. And therefore, if the department removed me, citing that you don't have qualifications, I may no longer have a case. But the problem is here, I was removed and somebody was brought with the same person who doesn't have the same.
But then his appointment was before you. How can you be removed and he would be taken in your place?
Exactly. Therefore, it is illegal. He was appointed for a headmaster, not for science teacher. When he was appointed.
One thing, just clarify. Now, you are saying that NCT laid down qualification will apply to you in terms of the notification of 2010.
2010.
Okay. So it means that your service came after 2010. And he will be guided by the 2001. That means his service was before you.
Yes.
So how can we take a case of replacing you by him? It means if he was there already into service before you, there could not have been an opportunity to replace you by him because he is already in service.
What happened in 2002 when the school was established, when he was appointed, 4 teachers were appointed. And he was appointed for headmaster. Another Mr. Rahman was appointed for science teacher.
4 teacher including him?
Including him. Now, he was never appointed for science teacher from the beginning. He was appointed as a head teacher only. Now, this was continued.
So, head teacher is portfolio-less. I mean, like without any subject.
Yes. He may teach some arts paper.
Can it be not like that? That a science teacher becomes headmaster also, or a maths teacher become headmaster also. It cannot be like that.
But because at that point, science teacher was particularly appointed.
No, but then
so he was not a science
teacher. That means the head teacher will otherwise not discharge any teaching.
He was teaching. He was supposed to teach. He was supposed to teach. But admittedly,
it sounds very unusual if you say that he was appointed a head teacher and not as a science teacher.
Yes.
But then he may be some other teacher at least. He may be for other stream, other subject. May not be for science.
May not be for science. Other arts paper, he was appointed. He was teaching those paper. Science subject was particularly appointed. So he was not for science teacher. Now, if he was appointed for science teacher in 2001, fulfilling the norms of the regulation 2001, then there is no question of replacing me also, because he continued. In that case, the authority would cite that no.
Okay. Now, the thing is that it means that the implication is with regard to the sanction post.
Sanction post.
Now, this school is under SSA.
SSA norms.
So, it has how many posts, sanction posts?
Three posts.
3 posts?
Yes.
One science?
One science, mathematics, and language and social studies.
Language and social studies is 1.
Yeah. Language is 1 and social studies is 1.
It means 4 positions.
So 3. But science includes
Science,
mathematics.
Maths is 1.
Science math is 1, language is 2, and social studies.
Science,
Now,
math,
this requirement came subsequently.
So it means SSA scheme came in
2002-3. It came in.
He was appointed before that. He was he was there in the school before.
Yes, as a founding teacher.
Now this NCT norms, whether it would apply to a teacher who is not under a sanction post.
Therefore, NCT norms, my contention is not applicable to those teachers who are appointed contractual under SSA. Because all the appointment under SSA is contractual in nature. That is what.
So you want to say NCT norms will not apply to the SSA teacher?
SSA teacher who are contractual only.
So it means that will make you also qualified.
Yes, that is why I was appointed.
Qualified.
Yes.
Then he also qualified.
Yes. That is exactly. So qualified, and the question only arises, I was appointed for which sanction post? He was appointed for which sanction post? That is the only issue. Now
which state? What is the qualification for the teachers under SSA?
It's the same, Lordship.
It's NCT.
NCT norms is
same. What basis you say?
Lordship, one there.
Anything to show that this same set of qualification applies?
Yes, it's same for all the school.
No, you say yes, but then that has to be on some record, on document.
I'll just.
Please, you show.
Sure.
Yes, Mr. Shangresh, you continue. Just it's okay, Mr. Kharmi, please take your place. You find it out and then place it.
Yes.
Sorry. Say like. Anyway,
therefore, I want to shorten my argument also, since the Lordship has heard me in the earlier occasion.
No, you please give us a bullet points, because you see your writ petition is quite voluminous.
No. Therefore, my Lord, if Lordship allow me, I may come to the list of documents. I'll just show those annexures. It will be very clear.
No, the bullet points of your contention.
That I will keep, my Lord,
Yes.
if Lordship permits me.
Maybe 1 page and short.
Yes, that we will keep. I'll keep.
Yes, page.
Yes. My Lord may come to, I'll just show quickly. My Lord may come to page number 1.
First one.
Yes.
19/2010.
Yes.
Yes.
My Lord, this is the appointment of those teachers. On the recommendation of the Managing Committee of the Larmati UP is hereby approved. Sri Sundar Rai is the respondent number 7. PA pass as headmaster. Sri Raman BSc pass as science teacher. Sultana Sarkar HSLC Arts, HSLC class 12 only pass as assistant teacher, and Mr. Pakhar Siddiq as Hindi teacher. Fixed honorarium sunset. So 4 teachers are appointed. Okay. So admittedly for science, Mr. Raman was there. Rai is for headmaster.
Yes.
Now it continue. Lordship, may kindly come to page number 2. Mr. Raman resigned. Therefore, the MC resolved.
Page number 2.
Page number 2.
This is a meeting.
Minutes of the MC.
Yes.
On 25th April 2014. And Lordship, may kindly come to page number 3.
Yes.
The resolution. By this resolution, Raman resignation was accepted by the MC. In his place, I was selected and appointed.
You are?
Yes.
You are Nazrul Islam.
Nazrul Islam. Lordship, may kindly see resolution number 2. After prolonged discussion, the House of the Managing Committee approved empower the President to appoint Mr. Islam, science pass, a local candidate with salary as per SSA norms.
This is 2014.
2014. So this was my appointment, and I will start teaching there. And my joining letter, Lordship, can you see page number 4?
Now, whether that resolution was approved?
Yes, subsequently it was approved. I'll come to that.
Then where is your appointment? Next page.
The next page, appointment letter,
Okay.
Issued by the President.
Okay.
Yes. Thereafter, my Lord, page number 5. I was asked to join. I performed the duty and salary was denied. Therefore, my grievance was brought.
This appointment, which was issued by 4,
yes,
was it approved?
It was approved subsequently. I'll come to that. My Lord. So
all
page-
these documents are all those documents are part of your pleading.
Yes, yes. We just extract from the pleadings only.
Yes.
Yes. For easy perusal. So page number 5.
Yes.
The additional DC has passed his order for releasing of salary. And later on, page number 6, Mr. Sundarai, respondent number 7, has filed a complaint also that my appointment was not done by him. That is his complaint. And later on, Lordship, kindly see page number 8.
Your appointment was not done by him, by somebody else.
By the president, but he insisted that he should issue the appointment letter as a secretary. That is his contention. Now may I come to page number 8. District Mission Coordinator, page number 8, has reminded
Yes.
the post also. Just in continuation of his letter, it is to be stated again that as per the project approved board approval, every upper primary school sanction under SSA would be one language subject, one teacher for science and mathematics, and one teacher for social studies. Now he came to know that he is not holding any sanction post. Therefore, he became insecure. And later on, Lordship, kindly see page number 9 also, a reminder.
Reminder of what?
A reminder by the DMC
What?
to the, yes, for following the norms of the SSA. And Lordship, kindly see page number 10 is my approval, provisional approval. So by this, provisional approval was accorded to the petitioner, 2016. And still then salary was not released because the respondent number 7 holding the post of headmaster and the managing committee secretary, he refused. Therefore, page number 11, there was an order issued by the DMC also to release the salary. Page number 11.
Yes.
Yes. And thereafter, page number 12, Mr. Sundarai and other teachers also lodged a complaint that they did not receive any salary. Yes.
So you stand on the same footing.
Yes, yes. He said that they are also not receiving salary. In view of this withholding the salary, I filed a writ petition in 2016 itself. And after issuing notice, there was a compromise between me and the private respondent without involvement of the authority. And they reached a compromise, is page number 13. Compromise.
Where is the order passed in that case? What you
Withdrawal. It is there.
It is there in this list.
Yeah, it is there. Chronologically, I have arranged it so that Lordship may kindly appreciate the sequence of events.
No, but then you said that this compromise came after the order was passed.
No, after this Honourable Court issued notice, then there was a compromise between both of us, and this is the.
On the basis of this compromise, the case was
withdrawn. And Lordship kindly see compromise. It is page number 13.
Non-payment of salary. How it could be settled by both of you? Well, both of you allege that you have not received salary.
My lord, the events that took place at that point of time, prevailing situation was that authority also did not dispute my appointment since they have issued approval. Now, managing committee also, only the secretary, who is the respondent number 5, has a grievance with me, saying that number 1, he did not issue appointment letter to me. Therefore, he refused to recognize me as a teacher, science teacher. Now, therefore, after filing this, there was a compromise that, okay, I recognize you as a science teacher. I would also release the salary to you. And if I recognize you in future, you may take appropriate action. This is the content, substance of the compromise. Lordship, page number 13.
Okay.
Yes. And thereafter, compromise it was on 13 October 2016. I'll come. Signatures are there.
There are two compromises again, page 15.
This is the way they drafted, yes, deed of compromise and deed of agreement. It contains the same thing.
One is deed of compromise, so consequent
Spirit
of the
is the same thing.
compromise,
Yes.
there is the agreement.
Yes, yes.
But it is between two only. Government is not a party.
Two only.
Government is not a party.
The government is not the party. Letters are different, spirit is the same. Lordship, kindly see the withdrawal of the writ petition, page number 17.
Yes.
The writ petitioner withdraw the writ petition. and thereafter, for 18 months salary, past salary was released by the managing committee.
Now, it doesn't say that this withdrawal is on the basis of a complaint.
Yes, yes, that was
Now,
not
say
reflected
supposing, what is your prayer in that same the writ petition?
for releasing the salary.
2006.
That time there was no cancellation of my provisional approval also. And since he said that we will release the salary, you kindly withdraw the writ petition. So with that, he has taken his word.
So once you withdraw
Yes,
this writ petition,
yes.
the prayer made therein cannot renew it here. You
No.
cannot reiterate it here.
What happened after withdrawal? They have released, managing committee, including him, has released 16 months salary, the past salary.
Whether your writ petition, whether your copy of petition
Yes.
of the WPC number 201 is available in the record.
My lord, this is not annexed here. It is not part of this proceeding. But it is for the release of salary only.
Anyway, we'll just see. But then we may have to, anyway. let us
But
see.
if required, we will produce. If required, lordship required. Now, thereafter, salary was released, and later on, 89, because a new managing committee came into being thereafter. And new managing committee started, my lord, adopting a resolution, impugned resolution, started from page number 22 onwards.
What is this page 18 and 19? Not very relevant.
Yes. My representation,
Okay.
yes.
That's page
I put up
20.
representation, and page number, Roshim, kindly come, page number 22 onwards. This is the impugned resolution adopted by the new MC, including him. From there, they did not recognize me as a science teacher, and they appointed Mr. Sundarai as a science teacher.
Now, a headmaster, the person who was all along functioning as headmaster,
Yes.
he's been appointed as
A science teacher.
now he's a part of a managing committee, isn't he?
Yes.
And as a headmaster come ex officio convener.
Yes.
Oh no, this is a convener only. But then was this a part? How can headmaster be appointed again as science teacher?
That is why now he said that after he realized that he is not appointed for science
Now this has
teacher,
been- okay, this has been the proceeding of the okay.
MC.
Then what happens?
Thereafter, he also obtained the science qualification through open school because he knows that he doesn't have he is not holding any sanction post. So he has attempted to obtain the science qualification so that he can claim the appointment as a science teacher. So authority allow him to obtain, and he convinced the managing committee that please appoint me as a science teacher and kick out Mr. Nosru. And the managing committee say yes. So this is the collective effort. Resolution start adopting and removing me. Lordship, kindly see page number 23.
Yes.
Resolution number 1. It says on the top. After third-part discussion, it is resolved that the monthly salary of the teacher shall remain as government norms. It also resolved that the appointment of Mr. Nusrul Islam made by the then MC president beyond the knowledge and the consent of the headmaster, Mr. Sundarai, as such on a humanitarian ground and on basis of appeal of Mr. Nusrul Islam, this meeting allowed him to render his service as a sanctioned teacher temporarily just to gather experience without salary. Now this is the resolution adopted. This meeting discussed the illegal act of the MC
Just
president.
hold on for a minute. Now you say that you have been terminated because it says Nazrul Islam, the appointment of Nazrul Islam made by the then SMC president,
yes,
beyond the knowledge and consent of the headmaster.
Yes,
headmaster means
he.
So it means now his appointment, so he will give consent. Is it something like that?
Exactly. He said that my appointment was without his knowledge. Okay. So in absence of his knowledge, everything is illegal.
So that is what, by going by the same terms, means
Yes.
his own appointment. So what happens? He removes you from there,
Yeah.
and he himself
induct-
inducts himself there.
Yes, he induct himself.
Is it something like that? Appointing self.
Yes.
Is it something like that?
Exactly same. Exactly same.
And then whether this resolution has been approved by the state.
Subsequently, his appointment was approved.
So that's what is the basic norms which the state should adopt in this kind of things?
For him, there is no norms.
No, for the state. For state to approve certain things.
Yes.
Are they not guided by any norms?
Yes, exactly.
Or that they go on just approving whatever they feel like.
Exactly. Lordship would see those annexures also there.
Anyway.
State is in the
Yes.
And Lordship, kindly come to page number 24 also. Another MC resolution.
Yes.
And at the bottom serial number, Sundarai, headmaster, math science. Now he's claiming the chair of math science. He's signing as a teacher. And page number 25.
This is what? This is also proceeding of the managing committee.
Yeah, managing committee resolution. I challenge.
Now, who is the chairperson of this managing committee?
My lord.
And
here chairperson, Mr. Piswana Das.
Okay.
Chairperson is there.
Okay.
And signature at the bottom.
No.
Number 1, Mr. Sundarai Math and Science. And the next page 25. Now Mr. Nosrul Islam reduced to a science non-sanctioned post now. This is the MC resolution.
Okay.
Government approval still remained the same, but they reduced me to a non-sanctioned post.
Now this resolution also approved by the government.
Yes, it amounts to approval by the government because they have granted approval to his appointment.
Okay. So where is his approval to his appointment?
My lord, may I come?
Come slowly.
Yes.
Okay. The next page 26.
26 is another MC resolution where they say that I did not pass the mathematics subject in higher secondary school. This is the MC resolution. And another MC resolution, page number 28.
Yes. How many resolutions after resolution?
This is how a person strangulated the system. That system would reduce to this stage. Lordship, kindly page number 28.
Now here they say headmaster come science.
Headmaster come science and date of joining, Lordship, kindly see 17/1/2002. He's original as a science. That time he was appointed as headmaster only. Now he claimed because he wants to negotiate with the norms.
State has filed an affidavit here in this matter.
They are fine. I'll come to them. And thereafter, what happened? I'll come straight to page number 32. His approval and my disqualification. Page 32.
Yes.
It says, as per resolution number 1, MC, adopted by the MC, Narmati, declaring Sri Nurul Islam as disqualified for holding the post of assistant teacher of science and mathematics since he failed in mathematics subject in higher secondary examination, and appointment of Sri Shyamsundar Rai as headmaster cum science and mathematics teacher by adjustment is hereby approved by the undersigned. So he was approved, I was removed, and this was signed by Mr. Srimati E.P. Laskar, joint TMC, and surprisingly, this is his approval. And another approval was given to him again, page number 33.
Again, same approval.
Same.
Now here is approval of with regard to 3 persons.
3 persons, including Mr. Sundarai. And all the teachers are hereby approved provisionally by the undersigned. Same authority. At this moment, at this time, 11 October 2017.
There is no norms how
no norms. No norms. I'll come. No norms. Now, in my case, till this approval, my approval was not cancelled. I was still teaching there. And page number 34, my final cancellation. I was cancelled by the same authority on 16/1/2018.
Transfer school 1/5/2000, 5th December 2017.
Yes.
That means the resolution which you had shown us before, is it that?
Yes. Those resolutions I have shown. On that basis, they have approved. And there is no norms for him. Worship has correctly pointed out. In my cancellation order, they said not in conformity with the rules. Which rule not specified?
So That is the cause of action for you for file
Yes.
this writ.
Yes, yes. And I have challenged his appointment, his approval, and as well as my cancellation in the second writ petition.
No norms, nothing.
No norms.
Whatever you feel like you do, go on doing. And then what
My
else?
lord, then only I'll take a few annexure. Lordship, may kindly come to page number 38. This is the order issued by the government
Yes.
to adhere the NCD norms.
This is into which? What is the date of it?
Date of issuance is
2013.
13, yes.
Yes.
28 March 2013.
Yes.
In upper primary school, it mentioned BA, BSc pass, B.Ed, education. So these are lifted from the NCD norms.
Okay, so this is what this is. Then we get the answer of our query that this for even for SSA teachers NCT norm has to be complied with.
Now,
that is what will answer the issue.
yes, and Lordship, kindly see, take the pain to see page number 39 again. The next page is there.
Yes.
Is a continuation of that one. It is for renewal of contract appointment. Lordship, kindly see.
Yes.
Therefore, SSA appointment is always a contract in nature. Now, may I see? This is in continuation of this office letter such 20 March relating to renewal of the contract appointment. In this connection, I request you to kindly consider renewal of all those contract appointees of 2022, 12, both set pass and non-set pass. However, in case of fresh candidates, preference be given to those having 45% in HSLC except where local candidates are not available. Below 45 may also be considered. So this order relates to appointment of the contract. And according to me, my lord, this has a government, since it is a contract in nature, do not need to fulfill the NCT norms. But it says that those who are for contract appointment should have the minimum marks in HSLC. And the writ petitioner fulfilled this criteria. And since he fulfilled this criteria, he was appointed, appointment was granted, approval was granted. So this is my basis of my entry qualification. If this is not in conformity with the NCD norms, then I do say that yes, I don't fulfill the NCD norms. But according to me, I was appointed on the basis of this letter, qualification mentioned in this letter. So my humble submission is, my lord, the cancellation.
No, this is basically it speaks about renewal of contract appointment.
Renewal contract, and it says fresh candidates.
It will apply to people those who are already in contractual service.
Yeah, that's true. That's true. And it says the language.
It will not be applicable to the fresh entrant in contractual service.
My lord, may kindly see the language. However, in case of fresh candidate, it said. However, in case of fresh candidates, preference be given to those having.
Anyway, these are executive instruction, okay?
Executive instructions only. So on that basis, I was also found to be fulfilled and appointed. And therefore, my humble submission is, which if you allow me, I can cite some judgment, but subject to other side. My removal was.
Yes, okay, but then you can these things. If you file a bullet points,
I'll do that.
Give us a citation along with that.
Yes, I'll do
so
that.
That will be if you point out those particular paragraphs, then it will become easier.
My lord, I'll do that. So my humble prayer is impugned order need to be set aside. Those are numerous MC resolutions.
So you say this by virtue of this you stand qualified. I mean, like your submission is this.
Yes, yes.
No, but then that is then in such a case, supposing you want to say that since it says it's a contractual appointment and SSA is a contractual appointment, so this will apply. NCT norms will not apply.
Yes. That is my case. And the moment say that no, NCT norms apply, then I don't have qualification. So also the respondent number 7 has also do not have that qualification. So his appointment was also wrong. So in that even my prayer is set aside the impugned MC resolution.
See, like if we find that both of you are not qualified, then what happens?
But It is set aside the.
Then we cannot allow your writ, cannot grant your thing.
Well, my prayer for releasing salary may not be granted, but his appointment approval should also be set aside. And government can take a fresh decision. Because government cannot allow me to go away and retain the same disqualified person, ineligible person to sit in the same chair. This affects the quality of the students.
Yes, state. Say us what is the norms?
Lordship, as far as the
to be
qualification
followed?
of the teacher is concerned, Lordship, the NCTE norm is being followed, Lordship. That on the basis of this at page 38 of this list of documents filed by the petitioner, Lordship,
Yes.
page 38. This, Lordship, norms is applicable to all the schools.
No,
Page 38.
yes.
As you are aware that NCTE
No,
norms.
that is okay.
came-
What is then page 39? Then what is page 39?
This is regarding the renewal of the contract appointment only, Lordship.
No, but then your SSA appointments are all contractual appointment.
Yes, contractual appointment.
Then
But they are getting the funding from the central government, Lordship.
what?
So it is like an aided school, Lord.
that is okay. But then if you say this, say then is your both your these things are contradictory.
Hmm.
Then your page 38 and page 39 these are contradictory. You have to clarify on this.
Preference should be given to those candidates having 45% in HSSLC, except where local candidates are not available. Below 45% may also be considered.
What is SCT pass? SCT is what?
State eligibility test.
Okay.
Now they need to have
Who can take part in state eligibility test?
Yes, they can
Those who
take.
have the qualification.
Those who have the
So
qualification.
it means that 39 is not in contradiction with this.
Yes, I think it's not in contradiction with this. Now they need to be graduate with BLED and also MTET.
So what is the qualification prescribing state eligibility test?
They need to be for upper primary. They need to be graduate. Graduate.
No, we are concerned. Oh yes, we are concerned with upper primary here. Is it?
Upper primary.
So that is at par with this thing NCT directives or not?
Yes,
Or is
yes.
there is a difference?
Yes, it is as per
Are
the.
you sure?
Yes, Lordship. It is as per the NCT norms.
There is no difference.
There is no difference.
So then that view of the matter, then there is no difference between page 38 and 39. I mean,
38
it's
and
not in
39.
contradiction.
No contradiction.
Are you just echoing the court or the court saying, or that is your stand?
No, no, that is my stand. That is my stand. And this private respondent, Lordship, he was appointed prior to 2010. So he'll be guided by that 2001 regulation. Regulation 2001.
Who?
Private respondent.
He was appointed in 2000?
He was appointed in 2002, I think. 2002, prior to 2010. So he will be guided by.
No, but then that is okay. But then so far as, you see, 2002, his appointment was not under SSA.
Yes.
Isn't it?
Yes.
He was brought under SSA in 2017 by that resolution of 2017.
No, this school, it came under SSA in 2000.
What about his appointment? The contention made on behalf of the petitioner by the Senate Council is there that though he was functioning as head teacher, but then he was not appointed under SSA for any subject, any specific subject. For science, mathematics,
Science,
or
mathematics.
social
studies.
Yes, and language. Okay. Now that was done only in 2017.
2017.
Now, whether that was a fresh appointment or whether it was a regularization on the SSS thing, and if it is a regularization, then what are the norms? There appears to be two approval of appointment. One is provisional
Provisional.
and one is permanent. No. So how do you justify these two letters also? For the same person, you allow your officers to pass any order they want. If they are happy, they will pass order. If they are not happy, they will reject. Is it something like that?
Lordship, this officer also who gave this approval, Lordship, it seems he's not aware of the.
Then what you are
he's
doing
not
as a
aware.
state? Have you given free hand to the officers? And you stand up to justify their all those actions? Is it something like that? Or there is a clear-cut stand by the state? Now, according to you, this private respondent has qualification. He is qualified. What is your stand?
He's not qualified, Lordship. Private respondent also is not qualified.
So then if he is not qualified, then how his appointment can be approved by you?
Lordship, it seemed that the approval it was given without proper verification.
Have you consulted? Have you consulted?
Lordship, at the district level,
This case
they
was
just
filed in 2018. Have you taken any steps to consult it? See, Mr. Kharmi, it is not a question that you avoid the situation by giving evasive reply. You just tell us about what is the stand of the government. Don't be bothered about what you have to face in the courtroom.
Yes, Lordship.
So take us. What is your clear stand?
Stand of the
If
government.
you say that he is not appointed, have you taken that stand in your affidavit?
Lordship, in my affidavit.
It is not only in this case. This court has noticed in many other cases also. The education department has nothing, no norms, nothing. If an officer is happy, he will do whatever he likes.
At the district level, Lordship, they
No,
just
but then
give.
you are not doing anything. What you are doing?
Actually, there is some.
The other day, on the last occasion, this court had hard-on matter,
Yes.
which is pending from 2014.
Yes.
And now it is reserved. And we found that there are more than 14 affidavits here. And it's a really difficult situation for the court to come to actual finding. And you see, the education department is passing order this way also, that way also.
Yes. Lordship, as per
See, your mayor agreement is, if you agree, yes, you say it is not solving any problem. Just tell us what you are doing to solve the problem.
The appointment and selection of the teachers, Lordship, is done by the SMC. Is done by the SMC in SSA school.
Cannot be without your approval. This qualification is prescribed by you. Qualification not prescribed by SMC.
Yes.
Now, if they pick up anybody who does not have qualification, does it mean that just because they have picked up, you will approve it? Then what good you are doing there? Then what for you remain there? If you are education department, you are there to implement the rules. Then
the approval is, I think, as per the instruction, is by way of an agreement. By way after the selection, the names of the teachers.
But then what about the qualification? Requisite qualification.
Yes.
Reply on that. SSA will always be contractual because it's under a scheme. So long scheme remains there. If the scheme not there, they go back to their original position. Yes. We understand that part. But then if you say that, tell us, if you prescribe certain qualification, is it not your duty to follow that qualification, that prescription?
It is the duty
to follow. So then why you are not doing it? At the hearing, you stand up, you admit that respondent 7 is also not qualified. Then why you have approved this? Then we will do one thing, we will just record your thing, we will cancel both the appointment, we will say you advertise the post.
Because as per this...
That is the best thing, we cannot do anything more than that.
Yes.
This is your admission, you are state council, you have made these things. We will say it, we will record it.
Lordship, because even in this approval also, they just give the approval on the basis of the resolution passed by the SMC without even looking into the papers regarding the qualifications now at the district level.
But then that is done by you, isn't it?
Yes.
Can we say that government has vicarious liability?
No.
Are you not responsible for the action taken by your officers? Or you disown them? If you are not to support their action in the courtroom, if you had to say that they have not done in accordance with law, was it not your duty to cancel those orders which they have not done in accordance with law? Have you done it?
After this appointment, Lordship, there is no further order.
But then what do you want all those judicial order to be made by here? Then we'll make an observation. We'll say that you allow your officers to do whatever they want, and in the state room you do not defend their action, and you just say that they have done wrong. We'll record this and we'll pass order.
No,
Are you agreeable to that? We'll record it.
No, the situation is that here, Lordship, and he was appointed prior to 2010. And prior to 2010, that regulation, 2001 regulation is there. So under that, his qualification does not fulfill.
You're saying same
under
thing.
the norms also.
Mr. Kharmi, you're saying the same thing. You see, don't think that the court is annoyed with you. The court has nothing
Yes, sir.
personal. It is your officer section which you are defending here. Okay. Now, before you take a clear-cut stand, be mindful of what stand you are taking.
Lordship, as per my instruction,
now
Lordship,
if
is like-
you have one way, if you record your submission, the court what become easier. We'll say both of them are not qualified according to you, are not entitled to hold the post under SSA.
Lordship, as per my instruction, Lordship, even this DMC is not the joint DMC, they are not the authorized officer to give the approval.
So then, see, why you did not cancel it?
Because it did not come to the notice of the higher.
This case was filed in 2018. This was case in 2018.
Yes.
Then,
after this case, it has.
Affidavit in this matter. Have you said this? That these are not the officers who are competent to approve. Have you said that? So if you say that, that means this approval goes. Then we will say this has not been approved by any competent authority. That is what you have to say.
Lordship, because we cannot cancel that order because of the pendency of this petition, Lordship. In my affidavit, I have given.
Anyway, we are recording your stand and we will pass this order.
In my affidavit, I have
your
given.
first stand is that both the petitioner and the respondent number 7 do not have qualification. We are record. Then second thing is that this approval given by the officer is not authorized.
Yes. Even both the petitioner and respondent also, they are not disputing that qualification, non-fulfillment of the qualification.
Forget about whether disputing or not.
Yes.
Just maintain your stand.
Lordship, yes.
Yes, just
That
maintain
is
your
my
stand. See, because here it's a case you are defending, isn't it?
Yes.
So you are replying to their contention, nothing else.
Nothing else. I have received some documents, Lordship. I would like to place it before your Lordship. Those documents I have received regarding this.
What are those documents about?
Documents is about the this authorization of the of officers for appointment.
For appointment means like for approving the appointment.
Oh yes.
Then
That is there. I'm submitting on the basis of these documents.
These documents are dated when? This came issued when?
2013. I've received these
So
documents.
this was prevailing at the time when this
appointment was there.
Okay.
Was made.
Now, when you say that some officers, those who are not authorized, they approve. When they approve,
yes,
even in spite of the fact that they are unauthorized, when they approve,
Yes.
what action do you take
Eh,
when it comes to your notice? Do you take any action? Because your silence would amount to supporting their action.
Lordship, can we have a look at this one?
No, why you are diverting
authorization.
that? Just tell us what do you do? We'll see. We'll look at the documents which you are giving.
Yes, sir.
Yes.
I have give us the copy. Yes, just referring this matter to the court.
No, anyway, Mr. Karmi, if you refer to certain documents or not,
I have.
please,
I'll give them.
supply it to them.
I'll give
at
them.
least so that they should also have.
Video.
I have received this document like this on PDF documents.
Just see, you sort out it, these things. The court cannot help you. You see, if something is not legible, you see. Except for the facts of the case, I don't think you have any disharmony between you, isn't it? So, at least do not burden the court with all those things.
Yeah, remain united.
Okay, Mr. Karmi, at least answer to the query of the court. Now say supposing, now it is your stand, that the officers, those who have approved this appointment, were not authorized.
We're not authorized.
Now, do you intend to recall those approval? What is your stand in the affidavit?
Page 12 or paragraph 12 of my affidavit.
Just tell us why you are taking us to this. Why do you want us to read us? You just tell us. What is your stand in short? If you tell us, it will be shorter. If you read it, it will be longer.
The appointment here at last paragraph of, or last the last portion of this paragraph 12, Lordship.
Why you can
just Lordship, if I may take Lordship to this
now,
paragraph
so far
12.
as this case is concerned,
Yes.
just we're coming to it. Just to us these things. Now, what is your contention here? What do you like to contend? Your ultimate contention, since you say that petitioner as well as the respondent 7 both are not qualified. Now, what do you intend to do at this situation?
My assumption is that if both of them are not qualified, Lordship, so it should be scrapped. The entire
so their appointment should be cancelled.
Should be cancelled and issue a fresh advertisement. This approval which was given also, Lordship, it was not intimated to the higher authority, so there was no action.
So it means you are not supporting this. It means this approval you are not supporting in this present case, isn't it?
I'm not.
We'll come to your affidavit. What you say there?
Yes, I'm not supporting, and I'm not supporting any of the party here. I'm just placing the
approval was not intimated to higher authorities.
Yes.
Is it a requirement?
It should be intimated.
Why you say it's intimated? It should be. What do you say should be? If you say it's a requirement, then you say it is mandatory. If something is only directory, then it may not have a bearing so far as the legitimacy of the appointment is concerned.
Lordship, with regard to the norms, Lordship, with regard to the appointment, the norm is that when the school is brought under SSA, Lordship, the new managing committee is constituted. And thereafter, the selection of the teachers is done by the school managing committee. And the approval is by way of signing of the contract agreement. And thereafter, the appointments are issued. Appointment orders are issued.
Contract agreement between?
Contract agreement between the teacher concerned and the SMC.
So have you executed contract with?
In this matter, Lordship, it is not on record. It is not on record. Neither the.
So you do not have any information whether any contract is this thing?
No. Neither the private respondent nor the petitioner have brought it on record, Lordship.
So approval doesn't need any formal order?
There's no separate order. There's no separate order.
So you want to say approval doesn't need any formal order. Execution of the agreement is the proof of approval.
Yes.
Just be sure
yes,
what
yes,
you
Lordship.
say.
Yes. That is what I have been instructed. And I've got the sample agreement also, Lordship. Contract agreement. Copy of this sample copy of contract agreement. If your Lordship wish to
just a minute. Mr. Shagreshu, you have any agreement executed? No.
Well, both the parties, we don't have.
Even the respondent number 7
They
also.
don't have.
Regarding appointment, Lordship, that is the norm.
So it means none of their service is regularized under SSA.
Yes.
Or approved under SSA. If you had to go by his contention, no formal order is needed. Yes.
Lordship. For appointment, that is the norm. And for the qualification also, the NCTE norm is being followed. Those two points, Lordship, symmetry. So neither of them, they are disputing that they are not qualified.
That is all right. Your affidavit in opposition filed on 4/12/2018.
My affidavit in opposition filed in WPC 473 of 2019.
473.
473 2019.
Not 248.
No.
We are holding file 248.
Yes. They also yes, fine.
248 also you have
Yes,
filed.
yes.
You refer to your affidavit in 248, Mr.
Yes.
Okay.
Karmi, that will be-
248, it's with Mr. KP.
Whoever it is. What is that other matter? Other matter is about?
My lord, that we challenged his approval in my cancellation order.
So ultimately
It is
same.
same.
Yes, what is that? What you are trying to refer, Mr. Karmi, paragraph 12?
In this WPC 473 of 2019.
It is the stand is not common in this 284, 248.
Yeah, at paragraph 12, Lordship, you have my affidavit. Just you have a copy of it. Yes, I'll give.
See, Mr. Just verify all those things before you start hearing. It's always only at the last stage you come. This is a case pending for 2018. Now, affidavit as per record, it is filed on 4th December 2018. And now you say that you do not have a copy.
248 copy given.
248 is not a case pending here. We are hearing 248 only. This is something not at all acceptable. How could you proceed with the hearing of the case without telling at the beginning that you do not have a copy of that?
How did I tell you to proceed on in this 248 given? Now you think.
This matter is not, it is hard at least for 3-4 days now. On the previous occasions also it was hard. Very unpleasant situation.
Lordship, I have borrowed this copy of the affidavit from my learned senior here. So your Lordship may produce this affidavit. We go through this affidavit.
You also do not have your copy of affidavit.
I have my copy, Lordship. I have my copy.
No, then you are
But only
referring
for
to
your
which?
Lordship's perusal, Lordship. I have borrowed one copy from.
No, which what affidavit? We are holding this affidavit. Just tell us which
Affidavit filed in WPC 473 of 2000.
No, what is the affidavit filed in 248? Why you are not coming there?
Yes.
Now, there appears that one affidavit of opposition filed on behalf of respondent number 124. 1 to who is 1 to 4?
State.
Okay, then who is respondent number 4? Then again another separate.
Again, this was filed subsequently.
Why? How many affidavits? See, what is the habit? How many pleadings are allowed in a writ petition? Absolute mess. Now you do not have a copy of that also?
Yes, that file is with Mr. KP. That copy of the affidavit is in KP's.
No, whoever it is, you are not having it. Both of you are there before the court.
Yeah. Paragraph 13, what? Paragraph 13 of this affidavit.
Paragraph 13
of this
affidavit filed on?
Filed on 4/12/2018.
Yes. Paragraph 13, what does it say? This is not the same which you wanted to refer. Compare with your affidavit. Yes.
This completely.
So what? Can be completely separate. It was filed in December. You do not check the case records also. If at all any affidavit is filed without giving a copy, is it not your duty to see the case records and then to point it out? It is something which was, as per our record, was filed in 2018. Now, after 6 years, you stand up for final hearing and you say that you do not have a copy of it.
When copy is given, then we believe it is correct to get no others. So I am having one copy.
Copy of?
When opposite party is given as a copy.
Yes. So the copy which you are holding, it is not correct.
This is not this one.
But then it is a copy of that affidavit opposition 248. Mr. Shangresho, this way we cannot decide a matter. It's not possible. If that is the situation, it is extremely sorry state.
But I understand.
The matter is handled by professionals, and this is the situation. It is not possible. You see, do not expect the court.
I'm sorry to say this. This happened off and on, and this is quite unprofessional.
Yes.
Final stage of hearing, then to continuous hearing. Otherwise, the contention of the writ petition by both the parties are same. The pleading has to be ensured long ago. That I understand.
Mr. Kharmi, is it that your stand in 248 and this other petition, these are different? So far as the state affidavit is concerned.
It's the same only, same.
It's why, then what is the difficulty in getting this paragraph which you wanted to refer in that other writ petition in the present matter?
This is prepared by my colleague.
But then you say it is same.
Hmm?
You say if it is the same, the who prepares it is immaterial. Then why you stood up then to argue that 248? We were arguing that 248. You should have allowed your friend to argue the case.
Lordship, I apologize, Lordship, because at the time
Mr.
when this
Kharmi,
matter
why
was
don't you
called up,
understand? You see, it is nothing we do. You see, your apology will not help us. Why don't you understand?
when the matter was
It's
called
not
up,
helping
Lordship,
the situation.
he was
This
engaged in
court has
another
nothing against you personally.
court.
But then this is not the way case to be handled. At least when you stand up to argue a matter case, at least you should argue by placing the pleadings which are there in that case only. And for support, you can draw our attention to some other thing.
Yes.
You do not have the pleadings of the main case where you are arguing and you wanted us to go to somewhere else. And on the other hand, Mr. Devnath says that the copy which you have given him is not correct. Is it correct, Mr. that you have supplied him a wrong copy?
248. In 248 words are given. Subsequently, it is affidavit filed by the respondent of 4. And another affidavit with the 1 to 4. This is not given. Only the 4 is given.
There exists, so far as this record is concerned, there exists.
So,
See, initially there was an affidavit filed on behalf of respondent number 1, 2, 3 and 4 on 412. Then subsequently on 13 to have another affidavit filed on behalf of the respondent number 4. You do not hold this both the copies.
only 4 I. So on the basis of it, I have given by this. Right? I have prepared it. And this 473, they didn't give any copy. If I get the copy, then.
Yes, Mr. Sangharisha, what is to be done?
Lordship, may I pray? May
Even
they come
the
up on
court is
Monday.
also finding it helpless situation.
These are due to the assistance court properly.
No, then
there is a failure on our side, I admit. But Lordship has put so much effort for this matter
of course,
to
there
resolve
is no
the issue.
acknowledgement that whether it was served to, because they have filed it only by providing you a copy.
Right.
So by enclosing the proof of supply of copy to you, right, they have filed it.
Right.
And you see, like as you know, like probably they also have not addressed. The respondent number 7 also did not bother to ask for it.
It is their duty
And now
to.
when the water has reached higher, now those pleas are taken.
So if the learned does not say that he is it to have a copy of the affidavit filed by the state, though the contention is same in one, may I suggest let my friend give copy to him and come up on Monday or Tuesday?
The thing is that you given an opportunity to raise it. That is what the problem is.
May come up on Monday or Tuesday.
See, whether it is same or not same, he is entitled to a copy.
Right. So if I pray may come up Monday or Tuesday, subject to Lordship convenience.
This is the problem, Mr.
then
Venkateshwar.
go
You
through.
do not want to keep a matter
Exactly.
for such a long time.
Right.
Get it listed again and again.
Right.
Regarding the facts, Lordship, it's the same. The appointment, it was
you are
initially
you
it
are
was-
not able to point out those paragraphs in this thing. Now, what point you want to point out here? That also you are not finding it.
in that.
What you want to refer from your affidavit. Now, Mr. Kafi, you are appearing this matter.
248, Mr.
248
KP
you
is
are
appearing.
appearing. Now, is it that you take a common stand? Is it that the argument which Mr. Kharmi has raised on behalf of the stage, you support the same argument, you adopt the same argument?
He can clarify.
Please come this way. Mr. Kharmi, if you can just
Yes.
accommodate him. Now it seems like all this time Mr. Kharmi had argued the case, which basically is based on 240, writ petition 240. It is for this case. Now you were here, you were listening. Now, do you adopt a different argument, or you say that argument which is made, that is okay?
My lord,
still holds.
my lord, certain aspects, of course, I am not clear, my lord, because my lord, I have in the previous occasions also there were several cases regarding SSA, my lord. Now this agreement thing, my lord, this was not within my knowledge, because as far from my past experiences, what I remember, my lord.
You do not tell your
managing committee-
experience. See, Mr. We are not at all interested to know whether what is just you have stood up here to defend the state respondent. Just answer to query of the court. Just say that what is an approval under SSA, and who is the approving authority?
My lord, to my knowledge, my lord.
Mr. Kharmi has said that no formal order of approval is needed.
My
It
lord.
is the execution of the agreement, and that itself is the proof. Is the proof of agreement.
That I have to discuss with the department.
It's all right, Mr. Kharmi. We are not disputing it.
What
we take it as a correct because we are government advocate. So we take it as a correct statement. Now it seems your counterpart is not agreeing with you.
Yes.
If you disagree, then which of this court will decide? Which will what this court will take? It seems you have disagreement on one point, and which is vital for this court. Then, according to what is the procedure? Just tell us.
Lord, what I have seen, my lord, is that to my
Do not
knowledge.
say what you have seen. Just say
My lord,
what is
to,
your
to
instruction.
my
from
knowledge,
there.
my lord, the managing committee is the appointing authority, my lord, and subsequently it is sent to the government for approval, and the government approves.
So there is a formal approving approval
Yes,
order. So who gives
No,
the
my lord,
appro-
even in
who
this
gives the
case-
approval? Who is the authority who should give approval under SSA? No, it's quite interesting. We have to make something, and this should go to the government. At least they should know that the two different government advocates
My
are
lord,
making two different
since my
pleas.
friend is relying on the latest instructions, then I'll have to go by what he's stating.
Do not divert it. See, you may have, you are entitled to have your difference of opinion.
My lord, but since
then
my
at least it
friend
should
has
go-
stated that-
government must know that they have two sets of instructions, and two government advocates are making two different submissions with regard to the procedure to be adopted in this.
So, my lord, if that is so, my lord, I will go because
That is your submission. The court is not saying that.
my lord, that is exactly why I am stating, my lord. Since my friend is supposedly, my lord,
We'll not that.
thinking
We'll
about
just,
the latest instructions, I'll have to go by what he's
Mr.
saying.
Khan is also there probably. We may seek his assistance. We'll contact the Secretariat Education Department to verify.
My lord, I'll
See-
go by what my friend is stating, my lord.
Now there is a change. Mr. Khan, just please help us. Just tell us what is to be done. If your
Overhearing it, Your Lordship,
if your two
absolutely.
panel advocates take two different stand, which is this court?
Very unfortunate. Absolutely. In fact, it's a very serious matter.
But as far as my affidavit is concerned, no such thing statement is there, my lord.
What is
In the
foreign?
We are talking about a procedure, Mr.
Procedure and Lordship is foreign.
Because here is a question of provisional appointment also, my lord.
Now,
And
what can
provisional
Then
approval.
the court is what is foreign from the court is something very serious. The court is saying how can two government advocates take a two different stand? It's not about procedure.
And that is with regard to the procedure,
Procedure. How can you have two
not on the
different
facts.
stands? Yes, absolutely. I'm hearing it, Lordship, absolutely. I'm not in the seizure of the facts, so I was just hearing it. But what is foreign is absolutely correct. At least the stand should be one. The court can take any other view. But if the stand has been totally contradictory, it's okay.
You know, honestly, Mr. Khan, this education department cases, the real struggle. You cannot imagine what happens.
Lordship, I was
And
there
how
the other
many sets of affidavits are filed for genuine reason or for no reason, one for another. Even for something like a written argument that you take one stand, other side refutes it, that also is done by you.
It's very unfortunate.
And then, and you know, with what to do, without a real help from the government advocate, the court becomes.
At least, Lordship, I can request my friends in future if they should compare the
Not only,
affidavits.
but then
and,
how, which way we decide this case?
That is very true. Which is true. And the challenge before the court would be which affidavit should the court take over.
You are there. Please kindly take note of the
Yeah,
thing
Lordship, absolutely.
and do the needful.
Yeah, this is a serious matter. Absolutely.
We cannot mobilize this. Please
Lord,
Be sure, make sure you
Yes,
have
my
a
lord.
common set of instruction.
Yes, my lord.
Yes.
Mr. Sangresho, we'll have it on next week. Something,
Next week.
something first. These things. In the meanwhile, you prepare your bullet points.
From my
also.
side, I'll prepare.
Just give us bullet points so that we
Yes,
don't want to
yes.
waste time.
Yes, yes.
You see, problem is that you see when there is a lapse of time in between, the court forgets.
Right. Correct.
And then you see again you have to repeat the same thing.
Right, right.
It would irritate you. It would irritate everybody.
I'll do that.
And you ensure that you have all the pleadings, copy of pleadings for the parties.
Lord, in fact, my friend was supposed to give us a list of dates with documents.
We have given already.
You know, what has
That
fallen
was
from the
given
court
long
is
back.
just, what has fallen from
So
the
what
court
the
is before
petitioner
next date. It is exchange, whatever. Exchange, get it, Xerox, get the affidavit is ready.
Mr. Khan, please be mindful of what kindly.
No,
kindly
Lordship, absolutely.
Ensure
Absolutely, Lordship, I will
that
request
government speaks in one voice.
Absolutely correct, Lordship.
And especially when it comes to procedures.
Procedure part, absolutely. That is very important.
Any day next week, Tuesday, Wednesday. Yeah.
Not
Yes.
Tuesday, Wednesday, my lord. After a week.
No, no. Whatever
After a
argument
week.
will be forgotten again. Just for clarifying that point. Monday or Tuesday,
It
in
may
fact.
come up on Friday next, my lord.
Friday is too long, mister. We'll have
Yes.
it on maybe Wednesday.
Yes.
I don't think that it needs so much of time to clarify the things which have.
My lord.
Yes. I'd landed counsel for the parties at some length. Post this matter again on. Just give a date.
Both the
Do
methods.
not compel the court. You see, it may come to something things that you see some orders would prepare to be fast.
My lord, item number 4 is also same.
Item number four.
Number 4, train 4.
See, okay. Same order item.
Deeply obliged.
Obliged.
From the main list, hearing item number 6.
Instruction.
Yes.
My lord, on 4/3/2024, my lord, by the order dated 4/3/2024, my lord. This matter was heard, my lord, by the Honorable Chief Justice, my lord. So an
4/3?
order was passed, my lord.
4/3?
2024, my lord.
Yes, the long order has been passed.
My lord.
Yes, Mr. Khan. Matter stands decided then.
My lord.
Matter stands decided then.
Lordship,
If you see, go by the earlier order, though it came as a suggestion,
Lordship,
but then that is what
it came as a suggestion with a gratuity.
the court found that, you see, like it has a this suggestion came on the basis of certain finding arrived at by the
Finding
court,
arrived at
on the
suggestion.
basis of that 1983 SCC 387.
Lordship.
Now, if that be the thing, like what is your instruction then on the proposal of the court?
Lordship, the instruction, then, Lordship, what has happened after this? Lordship, there is another order of 6/6/2024.
After that, what's the order dated?
When the matter was listed before your Lordship on 6th June.
Anything contrary to that?
No.
No, my lord.
Just one, no contrary, only one line.
6. Order dated?
6 June 2024.
Yes.
So, Lordship, on that date, we had made a submission. We had received an instruction from the department.
Okay, the matter was adjourned for 2 weeks. Yes.
Lordship, and what the reason for adjournment was that because that was basically fixed for carrying out the earlier order. What is the instruction? The instruction we received was, Lordship, it was he was an ad hoc employee.
No, my lord.
The instruction, we have an instruction, Your Lordship. He was an ad hoc employee and his survey was never regularized. Because of this factor, there was no record in the document departments to show that he was regularized. Because of his status as an ad hoc employee, so that matter could not be considered. And then we made a statement.
Have you taken the stand in affidavit of
No, my lord.
yes.
There is no such a stand, my lord, in the affidavit.
Lordship, no, we have not taken that stand as such. But this.
How can you take your stand all those things at this stage?
Lordship,
after he has superannuated from service.
Lordship is absolutely correct because this was a suggestion which had fallen from the Honourable Chief Justice in the earlier order passed. So we were asked to consider the gratuity part whether to give a quietus. So then Lordship will kindly appreciate if he is an ad hoc employee and his condition has not been regularized. Now, if we choose,
it becomes very tough to believe that a person was in service continuously on a daily basis for how many years, and he superannuated.
My lord.
Lordship, yes.
He joined in the year, my lord,
But Lordship, we have received that instruction.
1974.
And if need be, not Lordship, if need be, then we can.
See, you will at least the AIG is not expected to be a.
No, yeah, Lordship is correct. Lordship absolutely.
See, the speaker will say, and then
not at all.
We will definitely see the legality or correctness of whatever instruction comes before you place it before the court.
Lordship, yes. So, Your Lordship, because the information we received was he was ad hoc and there's nothing in the department regarding regularization. So we had got back to them. Lordship, we had got back to them to do some more work.
Please, you do it. Otherwise, you see, like what appears from the last order, which has been referred to just now by the Learned Counsel for the petitioner. It appears that you see, like the prima facie suggestion came on the basis of the consideration of merit of the case.
Yes.
At least some aspect of it.
Some aspect, and Your Lordship.
Okay. So, like, if you say that there will be difficulty on this thing, then we'll have to pass a judicial order.
Yes, Lordship is correct. Because department on its own, Your Lordship will kindly appreciate it can't take a decision, dehold the rules on matter of regularization and then coming back to the court. That will be slightly difficult. Then it will open up a Pandora boxes. There will be not less than.
Just see. Try to give a quietus as suggested by the.
Lordship, yes. We're trying to find out if there is a way to settle by paying gratuity. Maybe if not, we'll hear the matter on hearing and Lordship and pass a judicial order.
This is better, you see, if you come to a settlement.
We'll make one more attempt, Lordship, to find out what is exactly the status. Nothing comes, Lordship. We'll go on merit and let the court pass a judicial order.
Just say. Just say simply just say on the request made by Mr. K. Khan, Learned AG. Another 2 weeks time?
2 weeks, Lordship.
Another 2 weeks time is granted to obtain necessary instruction.
Lordship.
Let me just point out these orders to the things. This court might forget all those things.
Item number 10.
Alright.